this bill to the House.
The question is that the motion be agreed to. I call Kelvin Davis.
Thank you, Mr Speaker. And the Labour Party, let's get it out there from the start, the Labour Party does support this. We'll do whatever we can to protect children from sex offenders. But our concerns still remain about why we are back in the House now, just 6 months after the initial Act was passed. We believe that's unacceptable. We also believe that the time frame that we're given to respond to the amendments is unacceptable. But that said, it is important, I agree with the Minister, it is important that we do sort this out. Although the debate in the committee stages did leave a few unanswered questions, and I'd just like to thank my colleagues for posing those questions, because it is our job to hold the government to account, and there are some questions as to why we're standing here in urgency now debating this. As the Minister has said, the bill relates to a relatively small number of offenders, and I agree with her. Any amount of child sex offenders is a number that's too big. But we are talking about 107 offenders, I believe, that sort of slipped through the gaps that the original legislation left, and we're now closing those gaps up. Some of the questions that we had around during the committee stages around this bill, and the Minister said this is about release conditions, and yet the words release conditions were left out of the original bill. For those people who are listening, release conditions and standard release conditions as they are in the Parole Act of 2002 are, for example, offenders reporting in person to probation officers in the probation area where the offender resides, or offenders notifying probation officers of his or her residential address. They're not to move to new residential addresses without prior written consent. If they do move, the offender must report to a probation officer in the new probation area not later than 72 hours after the offender's arrival. The offender may not reside at an address which a probation officer has directed the offender not to reside at, must not engage or continue to engage in any employment or occupation in which the probation officer has directed the offender not to engage or continue to engage with, or not to associate with specific people or classes of people, such as gang members. So those are just examples of the standard release conditions for those people who are listening into the debate. But what the point is that something so essential as the identifying the release conditions should have been included in the original legislation in the first instance, and it's not something that we should be debating at this stage. It's quite fundamental, you would think, to have been included first time around. There's also a bit of a gap between convictions of these offenders and the sentencing, and as we know, conviction happens first. A conviction happens first. There might be a gap of a few weeks or months before an offender is sentenced, and it sounds like that that gap there was a bit of another loophole where people slipped through. Then there was the issue of quote unquote conditional release compared to release conditions, and I've already spoken about release conditions, which are something that an offender has upon release from prison, the conditions that they must adhere to, which is a different situation to conditional release. Conditional release, to me, assumes something that's going to happen before they are released. Then, as Claire Curran first raised, she spoke about corresponding registrable offenders. In other words, people who have been convicted of an offence in an overseas jurisdiction, and we have a whole couple of sections dedicated to these corresponding registrable offenders, Clause 5 being one of them, which is Section 8 amended, and then Part 2, Clause 3, basically Clause 3. It's a whole couple of clauses dedicated to these corresponding registrable offenders, people who have committed offences overseas. And yet when I asked the Minister in the committee stages about were there any people who had been convicted of child sex crimes over in Australia, had been spent time in detention centres, had been deported to New Zealand, the answer was that none of the 107 people that we're talking about in this debate were convicted overseas. And it begs the question is, why is there a couple of sections dedicated to something that doesn't exist? So what is the problem that we're trying to solve? There doesn't appear to be a problem, but it's been thrown in here anyway. And yet when we tried to get an answer to those questions, the Minister didn't reply. She said, "Oh, no, this doesn't apply to any deported people from Australia," and that's the exact question that we're asking. Well, why have people been missed out, or why are there these two sections dedicated to something, to a problem that doesn't exist? And it raises the question again about, how did the government get this part wrong? Maybe there is an answer, and maybe in this third reading some of the government members will stand up and explain to us why we're debating sections that are irrelevant, that don't apply to any people. So, Mr. Speaker, it's right that this bill is going through the House. It's also right that the opposition parties from around the House challenge the government on this, on why they got it wrong in the first place just 6 months ago. What was the situation that made them realise that we need to fix something? Why is it that we're actually trying to fix some problems that don't actually exist? And it calls into question, what's going wrong over there on the government side. Oh, no offence there to the colleague Nathan, the guy who just walked in. And yeah. What's happening here that we're having this debate now under urgency, and what are the problems that are being fixed? What are the problems in terms of the corresponding registrable offenders that we're trying to fix? You understand that there was gaps, that there were these 107 people that sort of slipped through that little window, as I said earlier. Or as has been said through the debates, that there are three groups of people who this actually applies to, and I'll just read out who those three groups are. Child sex offenders serving short-term sentences of 2 years or less imprisonment who had reached their statutory release date before the 14th of October 2016, had a sentence expiry date after the 14th of October 2016 and were subject to release conditions at 14th of October 2016. That's one group. The next group is child sex offenders on long-term or short-term sentences of imprisonment who reached their sentence expiry date before 14th of October 2016 and were on release conditions at 14th of October 2016. The third group, child sex offenders who were convicted of a qualifying offence before the 14th of October 2016 and were sentenced to imprisonment after the 14th of October 2016, or sentenced after 14th of October 2016 to a non-custodial sentence and ordered by the court to be placed on the register. To those people listening out there, it all seems just a bit too technical and jargony, but I guess the reality is that we have to keep our children safe from people. They will be on a register, and they will have to provide the police and the Department of Corrections with access to personal information that allows those organisations to proactively monitor an individual child sex offender's risk of offending while in the community and to act accordingly to address that risk. The Labour Party agrees that that needs to be done. We don't like the way the process has been done. We don't like the bungling of the October 14th, 2016 legislation, but we are glad and happy to take our part in making sure this legislation is hopefully right this time around. Kia ora.
I call Kanwaljit Singh Bakshi.